Okay, so we can go on now to number 5, which is to receive a presentation, discuss and direct staff on changes to 10.16. And I'm going to turn this over to Assistant Deputy Attorney Steve Swikert.
Yes, I'll just have a few brief comments before I turn this over to Donald Kudler for his presentation. He's going to make a presentation which does not necessarily represent the views of the county one way or another. We originally had in the bill that you just went through a section to deal with 1016 for dangerous and vicious animals. There's a major flaw in that chapter insofar as it does not provide for any hearings for animals declared dangerous. As you know, at the last meeting you had a hearing for vicious animals. It's provided for, but dangerous is not. So we want to make changes at least for that. We currently do provide hearings, but it's not specified in the code. And the manner in which you provide due process can vary quite a bit, from almost nothing to something as complex as a trial, and it is within the discretion of the county and to some degree this body to provide direction for that. So without further ado, Mr. Kudler will provide a presentation approximately about 10 minutes.
Thank you, Mr. Schweikert. I'm going to keep this as quick. Hopefully I don't go too fast. Did you all get the packets that I put together for you? Okay, I'll bring those up as we go. Kind of want to talk about 3 general issues. One is the constitutionality issue of the ordinance as it stands. The second part is meaningful hearings and rules for those hearings. And then the third part is that the definitions of vicious and dangerous should be the same as those that are in the state of Nevada. And actually, I can take care of that one pretty well. Let me go ahead and go through the others. So if you're going to take property, if the county, the government, whether it's the county, city, state, federal government, is going to take property from a person, they have to give them the certain due process rights. And the issue here is that part of that is a meaningful hearing, and I'm going to address that. The problem here is the county ordinance haven't given you guidance, haven't given me as an attorney, or haven't given the general public what's going to happen at a hearing. It's very broad and very vague. I'm going to put up, and this is the first paperclip section of the Declaration of Vicious Animals. And this happens to have been the one from the case that I appeared on last month. You can see that it's personally served. Now, one of the issues here is personally served or by mail. We think it should be just by personal service. The problem becomes that you have to respond within 7 days. Now, suppose that Animal Control, under this rule, mails out this vicious animal declaration on this coming Monday. Under the rule as written and under the definitions that I've seen as days, unless I'm missing something, 7 days is 7 calendar days. Now, in the court world that I work in, when we talk about 7 days, there are certain definitions. It says 7 days. If it's less than 10 days, an action has to be taken. If it's actually now it's less than 11 days, that intervening holidays and weekends are not counted among those days. And if the 7th day, that final day, or falls on a weekend or a holiday, then it goes to the next day. So if you were to have the vicious animal declaration mailed on Monday, this coming Monday, it goes out in the mail. Let's say it goes out late in the mail, and they put an affidavit. I dropped this on the mail at 4:35, 4:40, whatever. Went to the post office, got it dropped off. It doesn't actually go out until Tuesday, giving 2 days for mailing. Well, the 2 days after that is Thursday, but Thursday's a holiday, so it doesn't get there till Friday. Now the person's gotten on Friday, and let's say they're at work, they get home Friday, hey, there's a vicious animal declaration, this was mailed to you on Monday, you have to respond by Sunday. Can't do it. So I think that needs to be clarified. In order for this to be meaningful, you have to have a chance to respond. These are the kinds of things that need to be addressed, and some of them are minor and some of them are major. Now, when you get this declaration, it says we're going to have a hearing, but what is a hearing? There's a very undefined idea that we can come here, and again, this should be for dangerous as well as for vicious, but there's this undefined area that there's a hearing, and then actually there's an option of an informal hearing. Again, what are these terms? How is it meaningful for me? How am I, as a person who has an animal that's been declared vicious or dangerous, supposed to understand what that means? So we need to have some rules, and I included a little bit later down, actually it's the last thing in there, there's a couple pages titled from West Sacramento Municipal Code, and these are things just for you to look at later, but it tells you really what's supposed to go on in a hearing. I don't like everything that's in here. I think it needs to be broader than this. For instance, what's the burden of proof? The burden of proof in a taking should be clear and convincing evidence. It shouldn't just be the preponderance of the evidence. So it's not a 50%, it's a 75% or higher. If there are going to be criminal charges along with this, and of course you're getting to beyond a reasonable doubt standards. So these things should be clarified in here. Who has the burden? And it doesn't have to be necessarily in the Declaration of Vicious Animals. It should be somewhere. This gives the people guidance. This gives this board, this committee guidance as to exactly how these hearings should be held. Who's allowed to present evidence? What evidence are we allowed to present as the general public? Without that, you don't have a meaningful hearing because the person can't prepare properly. Now, I will say this, that I and Ms. Kay appreciate that when Mr. Allswing was contacted by myself as well as her, previously to her engaging me, we appreciate the fact that he said, look, here's what's going to happen at the hearing. It wasn't a necessity for him to do that, but he did take the time and the courtesy to say, this is kind of what's going to happen. Here's what you can do. You can prepare affidavits. You can prepare statements from friends and regards, and you can bring people to testify to these. This should not be something that's easier to find. So you have to give the people the due process. You have to give them the opportunity to be heard. The other issue that we have kind of is on that is, right now, the way the statute reads, I can make an accusation because I'm mad at Mr. Swikart that his animal is vicious and it attacked me and bit me, and then the dog gets taken. Well, if that's proven to be false, he's still going to be responsible to pay for that boarding of his animal, that time, and the $100 for the inspection. Anything that may happen, he's going to be responsible for paying, even though he did nothing wrong. So we need to make sure that this is done in a way that you're not forced and coerced, because when you sign the declaration, you're saying, yes, I'll pay this. I'll be responsible for this, regardless of who's at fault, regardless if I really did anything wrong, regardless of if my dog actually attacked somebody. So that's the issue in regards to the constitutionality. We need to make sure that these hearings are meaningful. We need to make sure that that the people are given due process before this taking, and that there is a right, and there is kind of some rights. They just need to be some stronger rights as to getting that animal released until, pending. It's almost like, well, the dog is proven guilty instead of innocent until proven guilty. It's guilty until proven innocent, and that's not the way this needs to be done. Looking at the definitions, and the last paperclip section that I gave you is the Nevada statutory definition. I know that the last hearing, Mr. Evans had some issues as to, well, what's the difference here? So here is what the difference is. The state has given the counties the authority to change the penalties, but has not given the counties the authority to change the definition of vicious. So with the state having taken this area up and said, here's what a vicious animal is, the county has no authority to change that. It must stick with the definition of vicious that the state has provided and dangerous as the state has provided. And what I did was, in this where it's highlighted blue, that says to dangerous, where it's highlighted yellow, that says to vicious, just to kind of, because it kind of goes back and forth in the county section, 10.16.10. There is no state definition of vicious for attacking another animal. Of course, this is not a good thing. We don't like dogs to attack other dogs or cats or any other animal, domesticated or otherwise. But you can't determine that it's vicious or dangerous based on harm to another animal. The state law and the state definition should be the only one used. So I think that's as fast as I could go. I don't know if anybody would have any questions or anything, but again, I know that Mr. Swikart and Mr. Rosenthal out in New York have been negotiating this, and it's my understanding that until such time as this is resolved, there won't be any killing of animals declared vicious or dangerous. I believe, is that correct?
Not quite,
Okay.
but it is something we are working on. We have a draft settlement agreement in place. We're definitely not planning on killing any dangerous or vicious animals without looking at all the circumstances. There are potentially ways of resolving it, like affording additional notice, allowing the animal to be removed to some other location. But we're not going to agree to hold on to an animal that's been declared vicious or dangerous, that there's no appeal going forward and the person just doesn't want to claim it. We're not going to be stuck holding onto the animal forever. But we do have a gentleman's agreement to some extent.
And I do understand what Mr. Swikart is paying. Obviously, if you were to give proper notice, personal notice to me, and I say, Don, your dog is vicious, it's attacked and bitten and caused substantial bodily harm to a person, and I go, okay, and I do nothing about it, certainly we're not dealing with the same position. We're talking about a position where there's an appeal process going on. I've put up, minutes up high. This is the request for hearing. Now, again, the request for hearing, the problem we have with this is that it says, I further understand that I am solely responsible for all fees associated with care and boarding of my dogs, including veterinary care. What happens if during the boarding the animal is injured at no fault of its own, and the owner is now paying the $10 a day or whatever it is, paying for veterinary care when it's not in control of this animal, and it may be the fault of the county, although my understanding is that the county does a pretty good job of taking care of these animals while they're in its possession. So you're kind of giving them a choice. You know, you're going to be responsible, you're going to be on the hook for this, and if the hearing is in 45 days, it's $10 a day, you're talking about $450. For a lot of people, that's a lot of money to say, well, you got a choice. You're going to be responsible for $450 regardless of the outcome of this case, or you give up your dog. That's the choice. That is not giving that person due process. That's putting the person in a bind, saying I'm going to commit to paying for this animal for boarding, when in fact, in many cases, or not many cases, but in cases, I can think of at least one that the animal was not vicious, did not attack, and it was on a false accusation that the county was doing its job to protect the public. And unfortunately, that dog was impounded for some time, and the owner was given a choice: pay or lose the dog. And I think that's what I have for now. And again, if there's any questions that I might be able to address, I'm not going to get into all the technical constitutional law rulings and such.
I have a question.
Ms. Cope, do you want to give any direction on how you would like to see 1016 amended? We're asking if you have any direction.
Well, I understand the 7-day issue, and I also understand the hearing issue, but you do have a hearing. It's just not for dangerous, is that right? It's just not the same hearing. It's a little bit different hearing than, isn't it, in front of animal control?
Yeah, well, it's with the hearing officer, and there's issues related to due process, and that's going to be worked out.
So you're gonna-
Regardless, yeah, that's going to be added to the code. I think we need to talk about other things, though. Obviously, with the two vicious at the last meeting being overturned, are there things that you want to see, aside from the changes that need to be made constitutionally? Are there things you want to see? Should we be holding vicious at a different standard? Should we be holding dangerous at a different standard? Things like that.
What about the issue regarding the 7 days? I agree. I mean, I deal with courts all the time as part of my job, and all of our language just says working days, or business days, or, I mean, that's something that I don't know if you've already looked at that or not, but definitely need to clarify that.
Is personal service a problem?
No, well, number one, the 7 days comes out of state statute. And so that's where the 7 days comes from. Under the vicious, under state statute, it's 7 days. The personal service is not a problem, and generally, I mean, my preference is that we do personal service. And so that's when I served Miss K her vicious declaration at her home. That's when I spent, I don't know, I was probably there for an hour and a half going over everything with her, looking at improvements that she had already started to do because of the dangerous declaration. And so, yes, we always shoot for personal service. There are times, though, that we just don't cross paths with the owner.
I think there's a lot of stuff that needs to be addressed. I don't know if we can do it all this evening, such a late hour. Should we continue that, or I don't know what the feeling of the committee is.
We will be bringing this back once we have another draft.
Okay, good. Yes.
Yeah,
I
again,
vote
though, if
that.
you do have any ideas, though, we'd like to hear them.
Well, one of the things that we can do, if we have ideas about how this can be changed, and it sounds like there are ideas, is to get those to Jason and let him know what your ideas are. So I think, and that way they can incorporate it into some of the changes that are being proposed.